Five, four, three, two, one. We are live officially. Okay. So how would we? Sorry.
Okay, we're live. Hello, everyone. We can go now, right?
No, hold on. Just give it like 5 minutes or so.
Okay.
LinkedIn just came up. See, LinkedIn just came up. I believe YouTube just came up. So hold on. Okay, I think we can.
Okay,
I
we're good to
think
go now.
start now. I think we can go now. Right.
Okay. Hello, we are good to go now, ma. Okay. Hello, everyone, and welcome to today's webinar on Start Smart Legal Building Blocks Every Startup Must Get Right. I'm Ijoma SK, a graduate intern with Adjunct Legal and this webinar's moderator. And with me is the phenomenal Norma Grace, a corporate and tech lawyer, and our speaker for today. Today's webinar is part of our H2 2025 series, a 5-month legal deep designed to help startups build smarter, safer, by tackling legal gaps. So from August to December, we're rolling out a rich blend of live webinars, practical freebies, expert led posts, legal services, and strategic resources, all curated to guide founders through the legal foundations they can't afford to get wrong. And I'm truly excited to be here with all of you, especially because legal missteps are one of the biggest silent killers of early stage startups. And the truth is, most of them are completely avoidable if you just get the basics right from the start. So, whether you're tinkering with a new business idea, you're launching your first product, or you're building for others, or you simply just have a brilliant idea that's keeping you awake at night, you're in the right place. For over the next 35 minutes, we'll be unpacking some of the most important legal foundations you need to build a solid startup. We'll cover areas like choosing the right incorporation structure, being strategic and protecting your founder's relationship from day one, your intellectual assets and how to protect them and monetize them, your corporate governance and how it helps you build a resilient corporate structure, how to be compliant with ease, and the documents you wish you had before fundraising. And this session is especially tailored for tech founders, business owners, entrepreneurs, and startup teams navigating Nigeria's or Africa's startup landscape. But even if you're outside the space, the principles will still apply. So if you're ready to build your startup on a solid foundation, let's start. Over to you, Miss Noma.
Thank you so much, Gemma, for that wonderful introduction. And so, without further ado, we will start with the foundation structure for your business. Now, incorporation is the first and most important step in your startup journey, simply because it defines how your startup will carry on in the future. Incorporation is basically the legal process of registering your business with the Corporate Affairs Commission if you're in Nigeria. If you're outside of Nigeria, there are specific bodies that are in charge of corporate or company registration. Now, when you want to incorporate your company or even a business, there are so many different structures for incorporating a company. You can either have a business name, or you can have a company limited by shares, or you can have a company limited by guarantee, a public company, a limited partnership, a limited liability company, or even an incorporated trustee. Now, these different business categories all have their specific and individual features. For example, the business name is a simple, low cost means of registering your business. Basically, you become the sole proprietor, but it offers no legal or liability protection. However, a company limited by shares, as the name goes, is the most common type of business registration and it gives you liability protection. That means you are only liable up to the extent or the limits of your contribution to that particular company. Limited companies limited by guarantee are social enterprises, for lack of a better term. They are companies that are engineered to push a social enterprise, like I said. So they are non-profits and they have a different set of rules that apply to them than the company limited by shares. And the same goes for public companies, which, as the word entails, they are public companies, meaning the general public has the rights to own shares in them. And on they go. But you would find that the most common and the most beneficial company structure or business structure to open for a startup, especially a tech focused startup, is the company limited by shares because it offers the most protection for the company. It has a separate legal entity or a separate legal personality where you become the company itself becomes an artificial person that is that means the company can own property, it can sue and be sued, it can enter into contract, and it is independent of its founders. It also has limited liability protection. There is a better access to funding. The company enjoys perpetual succession. That means even if something happens to the individual founders or shareholders of the company, then their assignees, their successors, or even members of their estates can take over the company and continue running it as the founders themselves would. There is also a flexible ownership structure with companies limited by shares. That means the easiest and the best structure to have, especially for a startup, most especially for a tech-focused startup, is a company limited by shares. Investors prefer it to having limited partnerships, and you would prefer it to having a public company that gives the general public rights and access to your company or to even the internal businesses that you run. Now, the next thing that is most important in any legal structure or even in any legal foundation is your founder's relationship. I see this all the time where people get into, building something together and they start building, they get excited, they don't have the hard conversations, right? They coast on we are friends until something goes wrong, and then everybody starts to, find what suits them and become selfish. Because, like the famous quote says, things fall apart, the center cannot hold. Founders in any structure, in any business structure, the founders, the partners are the center, they are the backbone of that company. And if for whatever reason they fall out or they stop being in alignment, you'll quickly find that that company starts to crumble like a house of cards because the center, the backbone of that structure has irretrievably broken down. Now, why is it important for you to have the tough conversations at the very beginning? Well, to prevent things like equity splits getting messy, to prevent boundaries getting blurred. Because at some point, when you're working with someone, you stop being empathetic towards them as an individual, as a human, and you start seeing them for their supposed output and for the things that they can and cannot do for you or even within the company. And sometimes that is wrong because we need to always remember that there is a human being behind the desk. There is a human being that goes through life, right? There's a human being that has emotional tension that can sometimes be burnout. And also, conflicts happen because, again, we are dealing with humans. So, it's always very, very important to have those very tough conversations at the beginning of any founder's relationship. Even if you knew the person or you guys were friends prior to the relationship or prior to the business entity that entered and came in between you guys. So now you will ask me, well, what are the tough conversations we should have? What are the questions that I should ask? What are the questions that I should ask before entering into a relationship, a worthy relationship with my co-founder? How can I ensure that I am number one, strategic with our relationship, and number two, intentional about setting the right foundation? Well, the very first question you need to ask yourself is how do I pick a co-founder? What attributes should I look out for when picking a co-founder? Well, I hate to be the bearer of bad news, but it takes more than skill to make someone a good co-founder. It takes way more than skill. The person not only has to be skilled at the task you need them for, but they also need to have shared values and a shared vision with your company and with you as a person. Because beyond the product you're trying to, put out to the public, you guys have to be in alignment both in your morals and in the vision and in the values that you share. More so, they need to have complementary skills. Because take the perfect example, a CEO cannot look for a CEO in a co-founder. It's like both of you will be doing the exact same thing, and that's wrong, right? So the next logical thing is a CEO looking for a CTO. If that's a chief executive officer looking for a chief technical officer, if we're talking in the terms of a tech company, it could also be that you are already technically inclined. You know how to work, you know how to write codes, and you know how to do all of the technological things that ordinarily as a CTO you should be able to do. Now, the next best thing is for you to look for, instead of a CEO, you could look for a chief operations officer, someone to actually move the needle and get the company from point A to point B, right? So your skills need to complement one another. You also need to have similar communication and conflict styles because it's very easy for people to go out of touch with one another when they are not communicating with respect and with empathy. It's very, very easy. So you guys as co-founders need to have similar communication and conflict styles. More also, you need to have a commitment level that you can reasonably work. Another perfect example, someone is at a stage of life where he or she can only spare a couple of years to build something, whereas the product that you're building will take a minimum of 10 years before it reaches its zenith or before it reaches times in quotes where it would really be appreciated. And then the other co-founder has only 2 years to commit to that thing. You would find quickly that when you start building with such people that have such differing opinions and commitment levels, when you get to the middle, one person has to break away. And sometimes breaking away like that can be detrimental to your company and to the thing, the product that you are building in generality. More also, you need to have a co-founder that is of the same risk tolerance or of a similar risk tolerance as yourself. Imagine you want to bet $1 billion on a product, and then your co-founder is telling you, "No, I can only handle a 1 million naira." You can see that the gap is very wide, and you both of you would be arguing all the time, back and forth, on the tiniest details because your risk tolerance levels are different, and that can stall any company's growth. You also need to ask yourself before picking out a co-founder or the attributes you need to look out for in a co-founder. What current stage of life are they in? Like I said earlier, someone might have 10 years to dedicate to building something, and another might only have 2 years. There's absolutely nothing wrong with either of those options. It just means that both of you are not aligned on what you want to do. And you need to find someone who is at a similar stage of life than yourself, or at least you have a backup plan for those stages where one person has to pick up more work than the other. There needs to be a backup plan if you are set on going with that particular person whose life is not in alignment with yours. Now, the truth is, it's really, really difficult to find someone with all of these features who fits each and every box, and you can take it and say, this person has exactly everything. It's very difficult to find, especially when you're starting off with, whether even your friends or when you're starting off with as strangers. It's very difficult to find. So, the next best thing is to pick your core non negotiables. What are those attributes that are non negotiable to you as a founder? Pick them, especially if you're the pioneer of the company. Pick whatever those non-negotiables are, and then you can compromise on the others. For instance, if it's non-negotiable, if it's a core thing for you and your co-founder to be on the same life trajectory, then you need to make sure that you find someone who is on that trajectory as you, and then you can compromise on all the others or on as many as suits you and vice versa. The next tough conversation, the next tough question you should ask when picking a co founder is, what do you bring to the table? What are your contributions? I've seen this happen a lot where people start companies, they start building together, and they are unclear as to what exactly they bring. Yes, you could have brought money, and you're also working. Yes, you could have, you're giving your sweat equity, you're giving your time, your energy, you're putting in your expertise, you're bringing in your network to make sure that this thing moves from point A to point B. How do you classify all that? How do you make sure that whatever it is that you're bringing is you're being compensated appropriately for it? How do you make sure that all of these are accounted for? By asking the tough questions at the beginning and specifying what it is that you are bringing so that it is clear to each and every person. Now, once you have decided or you have determined what it is that you're bringing to the table, the next logical question to ask is, okay, now who owns what and under what conditions do I own what I think or what I say or what has been allotted to me? Under what conditions do I own it? This is where the conversation of money and equity splits come in. How much percent is your ownership stake in that particular company? How much do you own in it? Under what circumstances? Are they preference shares? Are they ordinary shares? Do they vest over a specific schedule or do they vest outright? What do you own and how can you recoup? How can you get the benefits of that company that you own? Having the tough conversation on equity splits at the very beginning does two things. Number one, it clarifies the role of each person, what they bring to the company, what they bring to the proverbial table. And two, it allows you to determine a lot of factors, not only even the equity split itself, but how each person can cash in the equity that they own, right? What happens if one person wakes up and wants to have an exit? when you have the conversations about equity splits, you also inadvertently have conversations about exits. Now, the next logical question is, okay, now that I know my role, now that I know how to pick the attributes to look for in a co-founder that I want to pick, now that I know how much I own in the company and the conditions under which I own them, what exactly am I expected to do? Now, the first one is what you bring to the table, the idealistic attributes that you would bring to the table. This one is, what are the details? Give me details of what you bring to the company. For instance, I call XY amount of investors, or I go to XY amounts of places to publicize our product, or I handle the finances, or I give us details of what you do. The next tough conversation and the next tough question to have with the co-founder is, who decides what and how are decision deadlocks resolved? Now, when you are in a company with anybody, you would find sometimes that there is a chain of command. Even in any organization that operates any kind of hierarchy, even in the family structure, there are, like I said, a hierarchy, a chain of command that decisions go from one point to the other. The same thing is true of a company. Who makes decisions? You would find that it's usually the pioneer of that company whose idea was it to start the company in the first place. It's often them that decides, you know, the company decisions. They are the ones that make company decisions. Now, if there is a decision deadlock, let's say for instance there are two pioneers of the company and they both own 50-50 shares in the company. Now, how will decision deadlocks be resolved? You need to have that tough conversation at the very beginning to decide. This will, number one, keep you in practice with good corporate governance. And number two, it will avoid conflicts in the future. It will also present to the public, even to investors, that you have a unified front and you indeed know what you are doing in the company. Another tough conversation to have is who owns intellectual property and other intangible assets developed within the company. Who owns the IP? Nowadays, data and intellectual property is the new gold, literally. So if someone develops something that will be of huge public significance within your company, you need to know who owns it. Are you the creator or the developer, the owner? Is it the company that owns it? Will your co-founder or developers, independent contractor, will they own it? Having those tough conversations at the beginning with your co-founder prevents situations of that causes or lead to regret. Because now you know who owns the intellectual property in the company, and if you're creating or if you're developing any technology or any product, you have that at the back of your mind. How do founders start to earn money from their equity stake in the company is another important and very tough conversation you need to have. This ties in with our earlier question on equity splits because it's like, okay, I own X amount of equity in the company, but then how do I actually start to cash in that percentage? How do I start to make my money? Do I wait for until the company IPOs? Do I wait until there's been a corporate restructuring? Do I wait until it's been bought or sold? When do I actually start to earn the monies that I have staked? Or when do I start to receive or reap the reward for all the work that I have done in the company until that particular time? Having those tough conversations at the beginning saves you a lot. The last question for the tough conversations that you need to have with the co-founder at the very beginning is, what happens if someone wants out of the company? Say one co-founder isn't performing and the company in general wants that co-founder fired, or if all of a sudden the co-founders have differing opinions, what happens then? How are those things resolved? How does the co-founder peacefully exit the company without causing severe damage? How is a co-founder fired without turning the entire company into an opera? What happens when the visions no longer align? Well, the truth of the matter is these things happen. And the only way for you to be sure that when one person leaves, it doesn't throw the entire company into disarray is to have these things outlined in an agreement and decide amongst yourselves as founders that, hey, we are only going to leave when the company hits a major milestone. That milestone could be whatever you guys decide as a team that it is. Until you hit that milestone, everybody is in that company working all hands on deck, right? That's the only way. Because if you guys don't have these tough conversations, at the end of the day, you will find that avoidable conflicts happen more often than they should. You would find that you and your co-founder are misaligned. It will start that tension between the both of you will start to trickle down into the company, into your employees, into your independent contractors, your vendors, and every other person surrounding you. Remember, things fall apart, the center cannot hold. Founders are the center, they are the backbone of any business venture. So if you are a founder that you already have a co-founder, or you are even looking for one, you have to sit with yourself. You have to sit with your co-founders. Have these tough conversations. Have a founders agreement that evolves, a document that encapsulates all of these tough conversations and all of your ideas, your intents, and your assumptions in them, so that you avoid unmet expectations and avoid disappointment. You have to respect the person behind the desk. The co-founder is also a human being going through human trials. And you also have to make room and give whomever that is grace. When you do these things, you would find that you just might save your startup. But more importantly, it might save the relationship that started the journey of your company.
Thank you very much, Miss Norma. That was a really insightful breakdown. And listening to this, I think many of us can actually relate to what exactly the problem is currently with us, whether it's the challenge of choosing the right co-founder or figuring out how to strengthen the partnership we already have. It's one of those things every founder eventually faces. And the truth is, the earlier we start thinking about it, just like Miss Nova said, the easier it is to avoid future conflicts. So as we go on, I would like you all to just reflect on how confident you feel about your current founders relationship and the agreement you have, and if it can stand the test of time. Also, if you have any questions about navigating co-founder relationship, about incorporation, whether it's equity roles, responsibilities, or even managing conflicts, or anything we would say in the course of this webinar, we would love you to write them down in the comments. Just drop it in the comments, then we'll compile it and we'll attend to them during the question and answer session, so no one's left out. So thank you very much. Over to you, Miss Norma.
Thank you so much, Ijoma. Please, you guys, put in your questions as she has said. On to the next thing, without wasting time, is something that, to be honest, it's funny to me sometimes because founders think, or most young startups think, that corporate governance is relates to bigger companies only. So when they bring up such conversations, it kind of makes me chuckle. Corporate governance is a legal basic. It's almost it's the structure of your company itself. You cannot have a company without having some kind of element of corporate governance in it. Now, what is corporate governance? It is basically the structure, the system, the processes that your company has in place, the way that your company runs. What are those day-to-day systems that your company has in place that enables it to do what it does? And would also enables it to not only be transparent to its stakeholders, but to be accountable, to be fair, right? To take responsibility and to have all of the good practices that a company is meant to have. And corporate governance does not only apply to big public companies, it also applies to smaller early stage companies. Now, you're probably asking, well, why should I'm a small startup? I just started my company a year ago, a couple months ago. Why should I care about corporate governance? Well, if you want to, the reason why you should care about corporate governance is if you're waiting to have these processes until your company in quote blows, you would find that it's very, very risky. Having corporate governance gives your company clarity because now everyone knows their role and the level of their authority within the company. It protects your company's assets because now the personal assets are shielded whenever investors or there's debt or there's any other kind of liability there is. It makes you accountable to investors. It makes you accountable to yourself as a founder or even as a team member in a company. More also, it's attractive. Any investor that comes in and finds a company with proper structures that they keep to, it kind of attracts that investor. And who doesn't want to attract investors? It also ensures the longevity of your company because now your company has proper structures that guide the way that it runs things, the way that it does business, the way that it relates to vendors and other third parties. But these are all big words. In the day to day practice, what does corporate governance look like? Well, it looks like outlining everybody's roles. For instance, what does the HR manager do? What does the sales operative do? What is that, the developer that works remotely, what does he do? So that when he logs in, he knows exactly what he's supposed to do and there'll be minimal need for monitoring. What is each and every person in the company supposed to do? This is where your contract and your documentation comes in. For instance, founders agreement, it already tells the founders what each and every founder is supposed to do. Employee contracts, employment contracts tells the employee what they're supposed to do. Independent consulting contracts tells the consultant what they are supposed to do. So have clear roles and responsibilities so that there is no confusion and there is minimal need for monitoring. The next is to have a clear decision making framework. Like we stated earlier, when it came to founders' relationship, it's important to know who decides what and how to resolve any decision deadlocks. Because it doesn't it creates more bureaucratic nonsense where if a decision needs to be made in a company and you have to wait for the CEO to approve of it, you would find that things go by really, really slowly in the company. Whereas if the manager knew that he or she could approve of whatever it is, that thing could have been done a while ago, rather than having to wait until the founder comes or until the core decision maker in the company comes. So know who decides what. Don't leave all decisions in the hands of one person. It creates a one-man system, and that is not the goal or the essence of corporate governance. The next is a board of directors. In again, like I said, not having a one-man system. This is why you need and have a board of directors. Now, in Nigeria, we are allowed, or small companies are allowed to have only one director. In that case, it's just you and you can do whatever you like, in quote. But when you become more than one, say you're two, you're three, you're four, you're five, how is that board structured? Who makes what decisions, right? And how are decisions arrived at? And how do you track those decisions? How do you make sure that they are implemented? These are all corporate governance tactics. By doing things like giving notices for meetings or writing resolutions at the end of the meeting or even filing those resolutions and following up with them, with the founders, the directors, following up to see that they implement the decisions that were taken at the meetings they had. These are all corporate governance tactics. Another way corporate governance shows up in your everyday life is in financial discipline. What does that look like? Well, that looks like opening a separate bank account, not mixing your personal monies with your business monies. It's easier for so many different things. It's easier with tax, it's easier with your financial management, it's easier on a lot of different grounds, right? Helping you keep proper financial record and or auditor when your company can afford to do so or when revenue starts flowing. These all help make your company clean. It keeps it clean, it keeps it neat, and it keeps it attractive for investors. Corporate governance also shows up in your day to day practice as a business in the way that you are transparent with your stakeholders. Now, every business has four major stakeholders: there is the government, there are your employees, there are your customers, and there are your shareholders slash investors. And it's very, very important to keep each and every stakeholder happy in your business. Because if one stakeholder is angry or mad or pissed off with whatever it is you're doing in your business, you find that that kind of trickles into the rest and it slows down progress. And nobody wants progress to be slowed down. So being transparent and reporting all you need to report on time is a hallmark of corporate governance. And that's how it shows up in your day-to-day activities. Corporate governance also shows up in your compliance and legal housekeeping. What does that look like? That looks like filing your annual returns on time. There are some people there are some people that don't file their annual returns for years until they get struck off the register of companies. Meanwhile, they are actively operational. Why? That's a lack of corporate governance. It looks like filing your taxes on time, right? Ensuring that all the directors of the company, all the founders, or all the shareholders disclose their conflicts of interest if they arise or wherever applying for all of your operational licenses, updating and renewing all of the licenses when they are due, rather than waiting until you need them for one particular application or for one particular thing, and then you're running helter skelter trying to apply and get them on time. No, that looks like a company or an institution that is not prepared for business, and you do not want to give that impression of yourself. Now, there are so many more ways that corporate governance shows up in your day-to-day activity and your practices as a company. Because the overarching goal of corporate governance is to prevent a one-man system. That means every responsibility, every duty must be shared amongst people in the company. Now, how does the law help to make sure that corporate governance does what it's supposed to do? The first thing is, like I said earlier, they have given us room to have just one shareholder in the company. They have also allowed us to have virtual meetings, right? And we find that small companies are exempt from having company secretaries. So for bigger companies, for instance, for public companies, you must have a company secretary. But for smaller companies, you are not obligated to have one. You can have one if you decide, but you are not obligated to. But regardless of all of these many benefits that the Companies and Allied Matters Act has given us, we also find that directors, and this applies to founders as well, they owe a fiduciary duty to the stakeholders in the company. They owe a duty of care to those stakeholders because they need to be accountable. They need to be responsible for the decisions of the company because when you lift the veil of the company, you find that they are the ones that actually make the decision. And minority shareholders, no matter how many there may be, are protected under the law. So these are the many, many ways that corporate governance intersects into your actual operations or into the actual operations of your business. So you can't actually run a business without corporate governance. You will not scale. Or even if you do, you will run into issues at some point in time and you will find the need for corporate governance. That's why these basics are important because by the time you know them, by the time you understand them, it's easier for you to implement in your company across the board or through your entire staff. Another major legal building block that every company needs to have to set up the right foundation is intellectual property. We cannot stress this one enough. You must know who owns what, when they own it, and how they own it. It's not enough to create something. Well, it's not enough to even have an idea because everybody has an idea these days. What differentiates you from having an idea from you getting actual credit for it is in execution, in implementation. When you put whatever idea it is you have in a physical tangible form of expression. That's what gives it legal backing. Now, there are so many different types of intellectual assets and creative works that people come up with, right? But throughout intellectual property, they can only be grouped under four. And the four categories of intellectual property is your copyright, your trademark, your patents, and your trade secrets. Now, what are copyrights? Well, copyrights protect original works of authorship fixed in a tangible form of expression. So anything like your software codes, your written material, your artistic works, your website content, your product designs, your videos, your blogs, your music, your training materials, your technical drawings, anything that is an original work of authorship that you have fixed in a tangible form of expression. That means you can hold it, it's tangible, you can see it, you can feel it, you can sense it. It can be protected under copyright. Now, copyright inures automatically. Once you create something, copyright automatically protects it. However, to get any kind of legal backing or legal protection for that creative work that you have produced, you actually have to register it in the appropriate body or jurisdiction, or in whatever country or state that you're in. You have to actually protect it. And in Nigeria, protecting copyrights are fairly easy. And if you have something that you feel should be protected under copyright, then please, by all means, do so. Now, the next and seemingly the most popular intellectual property is trademarks. Trademarks are unique brand identifiers. So anything that identifies your brand in the market can be categorized as a trademark. So what does that look like? Your name, the slogan, the tagline, the color, the way your product smells, the way it sounds, audio visuals, every single thing that uniquely identifies your brand separate from others in the market is categorized or can be categorized as a trademark, right? There are so many different popular trademarks that we know these days. From movies, at the start of movies, you see this audio visual that plays. If you're a music, if you enjoy watching movies all the time, you find that you're able to even identify some of them. There's the Apple phone and the bitten apple on the side. There is Microsoft, there's Android and the sound that it makes when you put on your phone or when you put off your phone. These are all unique brand identifiers and they are all trademarkable. Now, trademarks typically there are different classes of trademarks and there are different use cases of trademarks. So it's advisable that you register in as many different classes and as many different use cases as you can, just so that you prevent infringement from happening with your trademark. Now, the next type of intellectual property is a patent. Patent protects inventions. Now, in most countries, Nigeria is one of them, patent only applies to hardware, right? Like physical hardware equipment. That's that's the only thing that patent covers. And that can be a bit limiting, but when you consider the fact that there's copyright to take care of the non would I call it the non-tangible things now, you would see that okay, patent actually does have its own role and it's playing very, very well. Now, patent protects inventions, whether that's a novel product, a process, a piece of technology that solves a unique problem, even a piece of technology that looks different from what it originally looks like, can be classified as a patent. For instance, when Apple first came out with the very first iteration of the iPhone, that was considered a patent. Not because phones didn't exist prior to that, phones did exist, but because the iPhone had a unique cover that other phones did not have in the market. It was very ornamental. The covering, the casing of the iPhone was very ornamental, and that passed for a trademark because it was a novel invention. No other phone in the market had that kind of casing like the iPhone had, and so many other examples of patents. So there are utility patents, patents that change the way something works, and there are design or ornamental patents, patents that change the way something looks. So whatever kind of patents you are designing or building or developing, it is very, very important. In fact, it is crucial for you to take accurate notes and steps of how you arrived at what you arrived at. Because when you're filing for patent, the patent registry and directorates will ask for those records to actually prove that number one, you did develop what you said you developed. And then number two, it was indeed a novel act because they want to see you figuring your way through it. Right. So that's that for patent. Now the next is trade secrets. Trade secrets are one of the most important intellectual properties there are. And I say most important because it's the one that has the least legal coverage. Now, let me explain what I mean by that so that it's not taken out of context. Unlike copyrights, trademarks, and patents, trade secret does not have a specific place or a specific body of the government or anything like that where you go to and register something as a trade secret. A trade secret is protected because it is a secret. Its value is ensconced in the fact that it is a secret. That's what makes it valuable. The moment it becomes public knowledge, it loses the value that it has. And the only way for that secret to be protected is for people to know, a limited number of persons to have access to that information. So, how do you, as a company, protect your trade secrets? For one, having NDAs in your company, having confidentiality clauses in your agreements with third parties. That is one of the many ways that you can protect your trade secrets. And also keeping your mouth shut. Not talking all the time helps too. So, anyway, um, the last for now, for the purposes of this webinar, the last legal building block that you need in your company, because let's face it, you cannot run away from it, is documentation. And we've actually, because the list of documents that you need for, especially as a company, or even the list of documents that you create as a company, they're quite a lot, right? And so we have created a checklist for you guys that you can access, whether you want to access it now or you want to access it sometime in the future. It's there for you whenever. And you have this checklist where you can literally plug and play it into your computer, your company. So just you can print it out, you can have it digitally, your choice. So you have it and you just tick off all the documents that you have. These documents have been created for people or for for companies in its early stages, right before they approach investors or right before they raise funds. It's what do these documents look like? Well, for instance, you have your corporate documents like your CAC documents, your MEMAT, your status report, your certificate of incorporation, your founders agreement, all of the resolutions that you have, your register of members, and then you have the cap or your equity documents like your cap table, very important in the financial world, your cap table, your employee stock option plan and policies if your company has an employee stock option available to its employees and top talent. You can also have safe agreements if you have entered into any such agreement with a third party. For financial documents, you need your financial For financial documents, you need your audited financial statement, right? You need management accounts, unaudited accounts, so that the actual bank statement. You need a budget and the operational plan. For your legal documents, you need all of your contracts. You need all of your intellectual property ownership documents. You need licensing agreements if you have any. These and many more documents are all that you need for your company, especially before you approach investors. So, in summary, these areas, whether it's the company structure, your co founder relationship, your governance documents, your intellectual property ownership, and the essential documents that you need, these are not just paperwork. They are the skeleton for your business because they determine whether or not your startup will be taken seriously in the business world. It will determine whether or not you can scale. It will determine whether or not internal disagreements or external challenges will be easily resolved or third parties will be invited. Startups naturally, by their very nature, are startups naturally are fast paced. They are unpredictable. Things happen. Markets can turn at any moment in time. But if you have these foundational elements within your company, you find that traversing all of these mountains in quotes in your company becomes easier because now you have the right structures. Now you have the right relationship. You have the right documentation. All of your um, all of the nooks and the crannies, the systems and the processes that your company has is all organized and it's easier for you to pick up and use whenever you like. So these are the building blocks that every startup must get right in their company for it to scale and scale sustainably. Thank you very much.
Oh, wow. Thank you so much, Miss Unoma, for this. Like, this is really, really insightful. Like, I've learned a whole lot personally. And just like you said, we are just going into the question and answer section right away. And we have a few questions, right? We have a few questions which we would attend to in this question and answer session. And the first question is, I don't know, Miss Noma, if you would want me to read out the questions, all of them, or you want me to read them out like individually. Would you want me to read them out together so you could attend to all of them together at once or
Yeah,
one after the other?
no, I think all together is better. So that it saves
Okay,
time.
okay. Okay, no problem. So the first question is, if two friends are starting up a business together and they don't have money for lawyers yet, what's the very first legal step they should take to protect their relationship and the business? That's the first question. Then the second question, someone says, I just started my business and a few friends are helping me with the design and the branding, but we do not have any written agreement yet. We just have mutual understanding and we've been vibing. But I'm worried that later someone might claim ownership of the work. From the very beginning, what simple steps can I take to make sure the company owns the work without making it too legal or quite complicated? Then the last question here is, in a scenario where two friends start a business together and maybe one person brings in the money and the other person runs the day-to-day activities, but along the way one of them loses interest or even leaves, what's a fair way for founders to set things up from the start so that it stays fair for everyone and also protects the business?
Okay, wow. We have a lot of friends, apparently. We have a lot of friends starting businesses, which is very good, which is very, very good. So let's take the very first question, which is if I'm just starting and I don't have money for a lawyer, how do I protect my relationship with my founder, my co-founder, who is also my friend? Well, the very first thing is if you don't have money for a lawyer, the very first thing to do is sit down with your co-founder and have the tough conversations. When you even talk about these tough questions, it will give you an idea of what it is you guys are working towards. My advice is again, if you don't have a lawyer, record the conversation. You don't have to physically type out something because that might seem a bit too tedious for you if you're not a lawyer. Record it with your phone, put it on a voice, a recording software and start talking. You could talk for hours. Let it be recorded. That way, if something happens in the future, you have that to go back to. It might not be written, yes, but at least it still serves as evidence that you actually put in the work. You had the tough conversations at the very beginning, and you were very strategic in your choosing of your founder or your co-founder. So that's that for the first question. Try and record it however you can. And when you get a lawyer in the future, you can always give that recording to the lawyer and say, this is what we discussed. Now the lawyer, it will now become their job to extrapolate all the things that we decided on during that conversation and add it into a document that evolves as the relationship grows. So that's the first question. The second question is what if everybody's building and you're having friends and family pitch in for designing things, developing things, writing codes and all that, and you don't have you're paying them. Are you paying or are you not paying? Ijoma, please remind me, are they
Okay,
paying or are they not paying?
okay. Here they said we don't have any. They didn't specify if they're paying or
Oh, they
not.
didn't
They just said
specify.
they are helping out with the design and the branding.
Right.
So I guess it's just on a friendship basis.
Okay. Well, if it's just on a friendship basis and they are helping out with the design, in quotes, helping out. Now there are two things you could do. You could either write an agreement that says, hey, once we're done building this thing, want a stake
Hello.
of whatever it is now. So
There
it's
was a
better.
short break in transmission, ma. Please, can
Oh,
you recap?
okay.
There was a break in transmission.
Right, right. Okay. So just to recap, right? If you are building something with your family and friends and everybody's doing it on a friendship basis in code, and they are developing things for you, they're designing things for you, they're writing lines of code and all that, you protect your ownership by doing two things. You either write telling them that this work that they have done for you, whatever it is a gift. You don't have to specifically write it, but make them understand that they are doing this for you unconditionally. You could do that, but then obviously they'll be like, why are you specifying that I'm doing this unconditionally? Do you expect this thing to reap this kind of reward? So there's that angle to that. You could also pay them a specific or a particular stipend. What happens is when you pay a stipend to someone for building something, it gives the impression that it is a work for hire. So you have hired them to do that particular task and they have done it, and so you are paying them for it. So my advice is always pay them a stipend. It doesn't have to be so much, but something within your budget that you can handle. So always pay them a stipend. It helps you even in the future because you can always then go back to it and say, oh, but I paid you for this work for hire that you did. And yeah, that's all that. So what was the third question? Sorry.
Okay, the third question was, in a scenario where two friends start a business together and maybe one person brings the money while the other person runs the daily activities, but then in the long run, that's along the way, one of them loses interest or even decides to leave. What's a fair way for founders to set things up from the start so that it stays fair for everyone and also protects the business?
One of the, again, it goes back to having the tough conversations, right? What do you bring to the table? How do I cash in what I bring? How do I exit the company? If I no longer am interested in whatever it is that is being built. Having those tough conversations prepares you for all of these eventualities. Like I said, like the question earlier, if you don't have the money for a lawyer at the moment, you can record that conversation, right? You can record that conversation, whatever it is, no matter how long it takes, so that when situations like this arise, you can then replay the terms of that conversation and hear what each person said and then end it that way based on what was said. Now, the entire process, it's always important to remember that there's an actual human being behind the desk, behind the output, behind the results that they deliver. There's an actual human being there. So it's important that you treat the person with respect and with empathy. You communicate as such as well, because once you communicate with respect to whomever, you find that things go a bit easier for you. And the last thing is deciding on your equity split and how to make the money back. Because once you decide, when someone wants to leave, it's easier for the finances to be split right down the middle. So I hope that answers the questions properly.
Yes, ma, I believe it did. Thank you very much for that.
Thank, thank you.
Okay, so we've come to the end of today's webinar. We've basically come to the end of this webinar, and as promised, we've put together some freebies for you all. That we have the investor data room check, a ready to use guide of all the documents investors expect before funding your startup. And then we also have the webinar notes, a written guide for those who prefer reading. You can get the full session of this webinar written down in a simple, practical format where you can revisit anytime. We also have the webinar replay link, which will be sent as well to your emails for. And then we have the startup self-assessment quiz, which is a quick test to see how legally prepared you are or your startup is, and you receive a personalized instant report based on the answers you gave to the test. We will also have the founders newsletter, which is our exclusive newsletter where we share legal strategies, startup insights, and regulatory updates. Like, this is very, very important, that directly affect your business and technology sector. So if you're not updated with the laws, with what's going on in your sector, you're going to miss out and lose out on a whole lot. That's one of the very important reasons you need to join our newsletter. Then All the resources from today's webinar, including the replay link and the freebies, would be sent directly to your email. We would also love to hear from you. What was your biggest takeaway from today's session? You could drop it in the comments, or you could share it with us on LinkedIn using the hashtag StartSmart or ArdinLegal. Then this is just the beginning of our H2 2025 Legal Deep Dive series. I'm so excited because we have a whole lot packed in for this year, for the ending of this year, for the last quarter of this year, our H225 series. You can't even afford to miss out on anything else because it's more like a step-to-step guide. Today we did the building blocks. So we're going to be building a foundation on top of these. We're going to be building on top of these foundations we've already started. And we will be back next month with another session to help you build smarter, safer, and stronger businesses. And on behalf of myself and Miss Nora Grace and the team of Agin Legal, thank you very much for joining us today. And until next time, build smart, build safe, and start strong. Thank you so much.